Hi everybody, welcome back to 10 Minutes with Griffin. I'm your host, Griffin Bridgers, and for this episode 129, we're going to talk about a little used strategy called the Lifetime QTIP Trust, and we're going to talk about how that may be a good strategy to get around issues with the potential retroactivity of tax laws that might be passed this year. Now, as always, this presentation is not intended to substitute for legal or tax advice and is provided for educational purposes only. Now, retroactivity is bolded here for a reason because what's on everybody's mind right now, the day after inauguration, is that a Congress that is largely Democratic could come in and change the tax laws, especially as it relates to the gift and estate taxes. So we're not going to really dig into whether and to what extent Congress could actually enact a retroactive tax bill. I don't want to split hairs about that. What I want to do is look at, assuming that they can, how do we deal with that from a gift tax perspective? Because here's the risk. We currently have a lifetime gift tax exemption equivalent of 11.7 million. But that could be reduced, and it could even be reduced to be effective as of maybe even January 1 of this year. So if you were to make a big gift today to try to use up that 11.7 million, and then a retroactive tax law took it away on an effective date prior to your gift, then all of a sudden you have a gift tax that you didn't anticipate at the time of the gift. So that's the risk, that's the cost we have right now for gift tax planning. And nobody has a crystal ball. We have no idea of knowing what's going to happen. So getting around this issue is something where there's a couple potential mechanisms we could use, but once you've made a gift, it's irrevocable. The donor of that gift can't take it back or control the gift in a way that might reverse the gift tax effect. But some of that control could be put into the hands of other people, and that's what we're going to look at. Now, in a previous episode, we talked about disclaimers and how maybe a spouse under a trust could disclaim back to the original grantor, but the problem is that's only useful for 9 months and has some other limitations, such as the inability of the spouse to use the benefits of the trust during that 9 months. But instead, what we're going to look at is another useful election called the QTIP election, which could be used for an irrevocable trust that's created for a spouse. So here's how it works. For a lifetime trust, you can make a QTIP election, which stands for Qualified Terminable Interest Property, if the following apply. 1, the trust is what's known as a life estate equivalent for the spouse. So in other words, all of the trust income has to go to the spouse at least annually. And while there is no requirement of principal distributions to the spouse, it means that nobody else but the spouse can receive principal from the trust, at least not as a distribution. Now, people could buy principal from the trust as an exchange for fair market value, but they couldn't receive that distribution if they're not the spouse. The other issue that's not looked at as much is that the spouse cannot have a general power of appointment over the trust assets in order for the QTIP election to be effective. So if you check those boxes, then you have the ability to make a QTIP election on the gift tax return that reports that gift for some or all or even for none of the trust assets. And we'll get into why that's important in a minute, but why the QTIP election is really important is because of the gift tax marital deduction. Generally, you're not taxed on transfers to your spouse, either from a gift tax perspective or even from an estate tax perspective. But that typically applies to outright gifts. If you make a transfer in trust to your spouse, sometimes it's known as a terminable interest, which means the spouse really loses the ability to benefit from that property during their lifetime or even at death. And at death maybe loses the ability to transfer that property as well. So in other words, at some point in the future, the spouse's beneficial rights or transfer rights will terminate, meaning that in most cases, a terminable interest does not qualify for the gift or estate tax marital deduction, but it does if it's structured as the life estate equivalent trust that I mentioned above. And as long as there's no general power of appointment, you can elect to apply the marital deduction to some, all, or none of the trust. Now, the trade-off is that if you make this QTIP election and apply the marital deduction, the elected assets will be included in the spouse's gross estate, including any appreciation on them. But that appreciation could be tempered because the intent is that these assets would be invested for income and not for appreciation. So appreciation shouldn't be as significant as with most investment portfolios. Now, another thing is that the non-elected assets will use the grantor's gift tax exemption and will not be included in the spouse's gross estate. So ultimately, the QTIP election is like a light switch. If it's turned on, the assets are taxed in the survivor's estate, and if it's turned off, the assets are taxed in the grantor's estate, and vice versa, and that applies to the gift tax as well. So, how is it used? Let's assume we have a grantor who's previously used none of their gift tax exemption. Maybe they want to use 10 million of that 11.7 million today before it's lost. So today, January 21st, they put 10 million into a lifetime QTIP trust for their spouse. And then later on, Congress, as anticipated, reduces the exemption to 3.5 million, effective back to January 1 of 2021, this year. So, down the road, when the grantor files a gift tax return, the trustee of the trust could make a partial QTIP election for no more than 3.5 million of the QTIP trust's assets. So what that means is that 3.5 million of the grantor's now reduced exemption is used, but the remaining 6.5 million doesn't use up any gift tax exemption, nor is it subject to gift tax because of the gift tax marital deduction. Now, if this had been a non-QTIP trust, such as a traditional spousal lifetime access trust, what happens with that retroactive change is that there could have been a gift tax of up to 2.6 million, which is 40% of the taxable portion of 6.5 million above the reduced exemption that applied retroactively to the time of the gift. But because of the partial QTIP election, we took that exemption equivalent and used up the grantor's exemption for gift tax purposes there. Now, the trade-off here, as I mentioned on the last slide, is estate inclusion for the spouse. So, at the spouse's death, 35% of the value of the trust will be included in the spouse's gross estate. We get that 35% by dividing the dollar portion for which the QTIP election was made by the total value of the trust at the time of funding. So why does this work, and why is this a helpful strategy? Well, you have a long runway. For any gifts you make in 2021, the gift tax return is not due until April 15th of 2022. So right now, that's a good 14 months away. Plus, you get extensions potentially as well. So that gives you a runway into next year to determine what's going to ultimately happen with the gift tax laws and the gift tax exemption. But the wild card here is what happens if there's no tax law change in 2021. So could retroactive tax law changes reach back into 2021 to a pre-gift date? Most likely they could not, but it's still something to keep in mind. And if not, what are your exit options? Maybe you don't want to have made this trust. So one thing you could think of is maybe not funding until April 1 and giving the spouse a disclaimer that could send the trust assets back to the grantor. And you could start over in 2022. But the problem with that disclaimer option is that the spouse cannot accept benefits of the trust in order to have a qualified disclaimer. And the big difference between a SLAT and a QTIP is that the QTIP has mandatory income distributions to the spouse. So a lot of QTIP trusts will say maybe distribute income quarterly instead of annually, because annually is just the largest frequency you can have. So if you want to have a disclaimer, you may want to say that income is not distributed more frequently than annually. that gives you the ability to claim that qualified disclaimer down the road as an exit strategy. Now, there are some limitations to keep in mind, especially when compared to a SLAT, because a lot of these don't apply in the case of a SLAT. For one, the spouse must be a U.S. citizen. You can't use the gift tax marital deduction for any transfer to a non-citizen spouse. Whereas with the estate tax marital deduction, you can use it for a non-citizen spouse as long as you put that trust into a qualified domestic trust, or QDOT. There is no QDOT election or option for a lifetime transfer, so you don't get that gift tax marital deduction. Also, a Clayton election is an option for the gift tax marital deduction, but most likely it couldn't apply for a lifetime QTIP. The Clayton election is available for an estate tax marital deduction, not a gift tax marital deduction. So you couldn't use a Clayton QTIP most likely for a lifetime QTIP. What that means is that the non-elected portion of the trust could not benefit other beneficiaries. You'd still have to maintain the life estate equivalent for the elected and non-elected portions of that trust. And speaking of that point, no principal could go to children or descendants during the spouse's lifetime, unlike a SLAT, which could benefit the entire family. Now, the spouse could make that principal distribution on their own, but they'd incur some gift tax in doing so. And in the event of a divorce, the trust can't terminate with respect to the spouse because that would violate the life estate equivalent issue. But in death, that's another story. We'll talk about that in the next slide. Next, you need to make sure that the spouse doesn't have an intentional or even an accidental general power of appointment, maybe through trustee powers or trustee replacement powers or anything, because if there's a general power of appointment, that means the QTIP election is not available, because the general power of appointment causes the marital deduction to be applied to all of the trust. You lose that ability to make the partial election, and thus none of the grantor's gift tax exemption could be used in that sort of a situation. Finally, for income tax purposes, it's important to note that the trust is a grantor trust, and you couldn't make it a wholly non-grantor trust. So that means the grantor or the spouse is always going to be taxed on all of the income of the trust. Now, it could be a grantor trust with respect to income, or not principal, or vice versa with respect to the grantor. But that requires some non-traditional drafting up front. I have a previous episode on that issue. I'd encourage you to go back and listen to that because it applies to SLATs as well. Now, one big hidden benefit here with a lifetime QTIP is that if the spouse predeceases the grantor can then become a beneficiary of the trust, mainly because the QTIP portion was included in the spouse's gross estate. So for that QTIP portion, grantor can become a beneficiary on the back end. You could have that reversion. However, that wouldn't be the case for the non-QTIP portion, because reversion back to the grantor would mean inclusion in the grantor's gross estate under code sections 2036, 2037, and or 2038 due to a retained interest. Now, that's the tax issue. You can have this reversion for gift and estate tax purposes, but for creditor protection purposes, this may not be the case. You want to check local law, because the reversion back to the grantor technically creates a self-settled trust, which could be void against creditors of the grantor. So you may want to check local law, and importantly note that some states do now specifically have carve-outs that allow that type of trust, but others do not, and others are silent on that. So that's an issue that's looming out there, that this may not be the best option from a creditor protection perspective if the grantor wants to preserve that reversionary right. As always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. But thank you for listening to this episode of 10 Minutes with Griffin, and I look forward to seeing you in the next one.